my presentation, I try to indicate which trends exist at the moment in European nationality law. And Patrick Baudelaire and I identified 6 points. We could have mentioned more points, but the main point is the equal treatment of men and women in nationality law. Very important is also to pay attention to the transitory facilitations. Nowadays, women are treated equally in nationality with men in respect of the transmission to the nationality to the next generation. But the point is, what with children of a mother who was a national, but the child was born before the equal treatment was introduced.
When we look at the reaction of member states concerning jihadism, what we see is actually there's been a very flurry of activity in member states. There are many member states which have reacted, adopting new legislation, and it's very legitimate. Jihadism is something we should fight. So we've seen reaction in the criminal sphere, but we've also seen that in many member states, new legislation has been adopted to use nationality as a counter-terrorism weapon. And if I look at the member states now, I can actually divide in two groups. The first group is a group of member states where the legislation has been adopted in the mechanism adopted is a two-step mechanism. What happens is then, first the person concerned is convicted by a criminal court because of terrorist act, and after that criminal conviction, the nationality will be taken away. That's the two-step process. In other member states, we have a one-step process. In those member states, we will not wait for the criminal conviction. The nationality will be taken away directly. And that's what will happen in the future in the Netherlands and what happens already in the UK. And that's much more effective because you don't have to wait for a criminal conviction by a court. But it's also much faster and you don't have the benefit of going to court.
We're talking about the nationality as a connecting factor in private international law. And there has been a tendency to say that it lost its relevance in private international law, but that's actually not the case. And nationality is still a very important connecting factor, especially in the European Union. But the law of the European Union changes the concept of nationality, especially regarding the fundamental freedoms. The dual nationality can be create a ground for discrimination on ground of nationality. And limping status relationships can impede the free movement of citizens.
And there are many future challenges in cross-border family law, and we've seen that the nationality as a connecting factor is still very important in family law, but at the same time we have all kinds of challenges. We have changing concepts of family, of parentage, co-motherhood, surrogacy. We have the difficult balancing act between private international law and migration law, so we have many challenges there, as the refugee flows to Europe clearly illustrate. And then we have all kinds of characterization issues. So there are many future challenges, and I think it's important to keep nationality principle in mind, but to keep in mind that it's lost its simplicity, and therefore we should take the challenge.
I was asked to talk about the future of the European citizenship for the Conference of European Registrars, and I took us through a little bit of history. I talked a little bit about the present and the context of the present, and then I tried to speculate a little bit about what it will be looking like in the future. What are the particular challenges, the challenges that stem from member states like the UK having a referendum, perhaps other member states might have a referendum. What does that tell us about European citizenship? What might European citizenship look like in the future? And I distinguish between the issues around free movement on the one hand and political citizenship, the right to vote in European Parliament elections. And I felt that those were both two very important aspects of citizenship, and I tried to bring those out because I felt that they illustrated something very important and potentially very, very complex in the future.
Asylum seekers, refugees and stateless persons in Europe have a specific situation that they're in, and they have a lot of obstacles that they face with regards specifically to birth registration. This may be obstacles that relate to evidence requirements that they cannot show due to their situation. Many refugees, for instance, and asylum seekers cannot show their documents because they lost them along the journey, or they didn't have them simply from the start. Stateless persons or persons at risk of statelessness might be able to acquire nationality in some country, but they do not have evidence to prove their identity. So it's crucial that states work together with NGOs, together with UNHCR, to provide for documentation and legal identity to these people. And first and foremost, the solutions to this is, of course, communication with the affected communities to increase their awareness of the importance of birth registration, because there are many people that still don't know why this is important and what is the birth registration procedure. But there are, of course, solutions to these situations, and among the most effective ones that we consider is, first of all, is outreach to the affected communities to raise awareness about birth registration and about the importance of having a birth certificate for their children. Secondly, this is amendments to legislation. There are still many laws that have to be amended in order to be in line with international law, and of course individual assistance to support them through the process, because the process is very bureaucratic, very difficult for them to grasp, and also translation should be provided.
Auf dem Gebiet des Familien- und Personenstandsrechts gibt es immer noch viele bürokratische Hindernisse in Bezug auf grenzüberschreitende Sachverhalte. Das ist faktisch eine Einschränkung der Freizügigkeit. In unserer Erklärung von Leuven fordern wir daher die EU-Institutionen auf, hier Maßnahmen zu ergreifen. Neben der Abschaffung der Legalisation bzw. Apostille sind ein direkter Austausch von Personenstandsdaten zwischen den Mitgliedstaaten und die Schaffung eines internationalen Privatrechts auf EU-Ebene dringend notwendig, um das Leben der Bürgerinnen und Bürger in Europa zu erleichtern.
Family law is on the move. People migrate, they take residence in another member state, and this has important consequences for family law matters, especially for international family law. The European Union has taken many initiatives to come to a unification of private international law, but I will try to explain that a unification of family law is not enough, and that this unification should be accompanied by a unification, or at least an harmonization of substantive family law.
But not an exercise born out of a crisis. A crisis was the financial crisis. Recall in 2008, after the first wave, we said never European banking control, never. It will remain a national matter.
When I heard all the presentations on this Congress, it's very loud and clear that the remaining differences are rather political and not cultural. It are politics, real politics, not culture. What remains is the professional expertise of registrars, exactly in the human face-to-face contacts between a specialist and a citizen. Hostmanship, as it's called, that's what it does. Where complicated issues have to be solved, often, of course, with cross-border connections. It's difficult, but humanity, that's what we stand for.
We live two magnificent days in Leuven. I'm very, very glad and proud that the Flemish Associations, my colleagues, that we could organize this conference of the European Association. And something what strikes me is that we have to fight for Europe and for the European project. And we will do that together. I'm convinced of that. And I hope that everybody who was in Leuven will remember Leuven as a place where Europe fostered an invitation to flourish in the future.
So it was a real honor for the city of Leuven to welcome you in our city, our beautiful city. I've heard that it was a very interesting event with interesting speakers, but also the leisure part of the Congress was very interesting in this very beautiful historical city, but also the capital of the beer. So it was a good combination of knowledge and of leisure.
Wir haben also einen hervorragenden Kongress gesehen, den wir noch lange in Erinnerung behalten werden. Wir hatten gute Gespräche wir hatten einen guten Gastgeber hier in Leuven. Wir haben eine schöne Stadt kennengelernt in Leuven in Belgien und alle Redner waren zu unserer Zufriedenheit und wir haben auch letztendlich ein hervorragendes Schlusswort von unserem Vizepräsidenten Simon Reistig gehabt, was uns alles sehr berührt hat. Und dann hatten wir den Film für einen schönen Kongress im nächsten Jahr. Darauf freuen wir uns alle. Und ein besseres Fazit kann es eigentlich gar nicht geben.